Hi, good evening, everyone, and thank you for joining us tonight. My name is Tanya Morkas. I'm the director for Dvorah, Women in Foreign Policy and National Security. We're really excited to host this talk tonight with Dr. Orly on the principle of distinction and the participation of women in armed conflict. Our event tonight is recorded and also live streamed on Facebook. We are placing all the participants on mute. However, you can use the chat on the Zoom, and you'll also have the chance to ask questions later on. Tom Gal, who is a member for Dvorah and of ALMA, will be moderating the discussion, and you can raise your hand and ask questions later during the Q&A. Our event is hosted by Dvorah, the Minerva Center for the Rule of Law under Extreme Conditions at Haifa University, and ALMA, the Association for Promotion of International Humanitarian Law. So just a few words about Dvorah. We're an Israeli NGO promoting women in foreign policy and national security. We're nonpartisan. Our members come from a variety of backgrounds, and we aim to broaden the topics that are defined as national security and diversify its participants. The forum works towards the equal representation of women in decision-making positions within the security establishment and policy-making establishment, in the media, and in academic and professional panels. I'm happy to give the floor also to Dr. Itamar Mann, the principal investigator at Minerva, to say a few words as well. Over to you, Itamar.
Thanks, and thanks for having us here with you. I mean, myself, it's really great to have the opportunity to listen to Orly Stern. I look forward to your talk. I just wanted to briefly introduce the Minerva Center, which, as you said, is located in the University of Haifa and is dedicated to the study of the rule of law under extreme conditions, which we define broadly, including natural disasters, national security issues, and socioeconomic crises. And we've been kind of ranging through these different areas over the years. Recently, of course, kind of focused on emergencies in the context of the pandemic.
Thank you. Our third co-host, Advocate Dvorah Rosenzweig, Director of Research at the Minerva Center and Chairperson of ALMA. He'd like to say a few words about ALMA.
Thanks, Tanya. It's a pleasure to host an event together with the Dvorah and, of course, my second home at the Minerva Center. ALMA, as the Association for the Promotion of International Humanitarian Law, was established 10 years ago by a group of then young researchers in the field of IHL. Tom Gal is here as a co-founder of the organization. And we also have in the crowd also Shaked, who is also a member with that. ALMA was established with the idea of promoting the knowledge, understanding, and discussion of international humanitarian law, where we don't care about someone's idea, agenda, or position, but we want them to be able to express that within the right terminology and understand the laws of armed conflict rightly, and be able to use it when they discuss and understand it. I don't want to waste much more time because I think Orly's presentation is going to be much more interesting. I just want to invite you all to follow ALMA on Facebook and Twitter, where we're using this event to relaunch our hopefully very soon our monthly IHL forums in an online version. And so please, you can follow us and be updated on upcoming IHL events. And much like this event, we have on our website and a webpage of upcoming IHL events where you can find information about live events from all over the world, not necessarily live events, but upcoming IHL events from all over the world, which under the current circumstances are usually online events, live events, and you can get updated and see them. Back to you, Tanya.
Thank you. So it's my pleasure to introduce Dr. Orly Stern, a researcher, consultant, and international lawyer focusing on armed conflict gender, security, and law. She's worked around the globe, including in Somalia, Iraq, South Sudan, Northern Nigeria, Sierra Leone, Central African Republic, Jordan, Uganda, and South Africa, and I'm sure I'm missing some more. Orly's consulted for various international organizations, research institutions, and NGOs. She holds a PhD in law from LSE and a master's in human rights law from Harvard University. And the reason we're here is because her most recent book, Gender, Conflict, and International Humanitarian Law, was awarded the International Committee of the Red Cross's inaugural prize for best published work on international humanitarian law in Africa. So over to you, Orly.
Thank you very much. Let me just share the screen. Are you seeing the presentation now? Yeah, great. Hi, everybody. Thank you so much for logging in to listen tonight. I'm very excited to spend the next hour with you. As they said, I've been a consultant and a researcher, and for the last decade or so, I've been working across a number of war zones, primarily in Africa and the Middle East, mostly in Africa. And the topic of tonight's research, which was the topic of my last book, was the work that I wrote about in my PhD and in my book, but it was also the product of many years in the field of working in various war zones and really coming to see the roles that women were playing in a number of African wars. And so it's been a lot of experiences in different parts of Africa that have brought me to this topic. Tonight I'm going to tell you about one particular part of international humanitarian law, the principle of distinction, and I'm going to look at what happens when you apply that particular body of law to women in African conflict. And I'll talk about the results and whether I think that this application of the law shows us that the law is a workable body of law or whether it points out certain problems of the law. Let me start off by telling you a little bit about the facts of the women in question. So I'm going to apply the law to these women. So I want to just set the scene by telling you a little bit about these women. So there have been numerous conflicts in the African continent over the last 20 or 30 years, many conflicts. And across all of these conflicts, women have played really interesting roles. Now tonight, I'm going to focus specifically on women in non-state armed groups. I'm going to focus on women in non-state groups because they've been the bulk of the women participating in African conflicts. And I think they're really the interesting ones. They're the ones that really paint out some interesting dynamics that we need to think about when we're thinking about the application of international humanitarian law. So let me start off by telling you a little bit about the roles that they play. They play a range of roles. And first of all, women have been involved in active combat in various wars. So in countries from Angola, Burundi, DRC, Eritrea, Rwanda, Sierra Leone, Somalia, Sudan, women have been involved in active combat. Sometimes they've even led battalions. They've been in leadership positions in fighting. Often they've carried out suicide missions. And I'll tell you a little bit more about women in suicide missions later on in this talk. So definitely we've seen women playing active combat roles. However, much more often than that, you have women playing support roles for armed groups. That's the main thing that they do. And these take various forms in different countries. Women act as guards, they act as spies, they act as intelligence operatives, messengers, minesweepers, porters, medics. They carry out a number of battle-related support roles, and often they carry out these roles very close to the front lines. And there have been some really interesting examples. So most of the last 2 years of my life, I've been working on the context of Somalia, and I've been working on a lot of research about Al-Shabaab, and particularly on Al-Shabaab women. And women in Al-Shabaab are a really interesting example because in Al-Shabaab, there's a very strict division between men and women for religious reasons. So men go away to fight on Al-Shabaab bases, and women serve the movement from the cities and towns. And the way people describe it is that they serve the movement on the phone. So assuming Al-Shabaab wants to conduct an operation in a town, like do a bombing in a town, what they'll do, they're based outside of the cities, and they'll call up their women and they'll say, we're coming into the city to do an operation, and the men will bring the bombs to the side of the city, but they can't get into the city, so the women will come in and fetch the bombs, and they'll take them to the particular places where they're needed. They'll store them. They'll take them to their stores in the market. Women will carry the weapons underneath their burqas because they're concealed. And then at the end of this, they help the men to hide, and then they clear out of the way. So you've got this interesting form of participation where women are setting the scenes, and this allows the men to conduct operations in towns which otherwise they wouldn't be able to access. So that's just one of many types of support roles that women play. That's just one example. What you also see a lot of is women playing domestic support roles for armed groups. So lots of armed groups across the continent have women living on their bases, and the women are there carrying out the sort of domestic roles that they would be playing at home. They're washing, they're cleaning, they're being wives, they're having children, they're looking after kids. But they're playing these roles and in order to keep these arms group going. These arms groups are very reliant on these women carrying out these roles. Often women will play a number of these roles concurrently. So you'll have women who some of the time they're out conducting a military mission, but the rest of the time they're at home washing and cleaning and looking after the kids. And these are all seen as various parts of the roles of these women. Now, what's really interesting in the African context, and I'm sure elsewhere, is that African women play roles in very gender particular way. They often keep to gender stereotypes. And often the way in which they serve armed groups are very much informed by African practices about the way that women should act. And I'll give you an example of how that plays out. So in South Sudan, you had many women who were spies for the movement. How would, whereas a man might be a spy in a certain way, women spies for the SPLM in South Sudan would go down to the river with their baby tied to their back and collect water and talk to the local woman, and they'd collect information from the local woman with their kids tied to their back. That would be, and so they would very much play the role, their roles as spies would take a particular form of the way the women acted in their society. I'll give you another example, which I really, really like. In Africa, you see across Africa, women carry water and they carry water on their head. You see it in countries across the continent. And it's one of the, women in Africa have become very practiced at carrying quite heavy loads on their head for long distances. Now in 2002, when the Lord's Resistance Army, that was the rebel group in northern Uganda run by Joseph Kony, when the Lord's Resistance Army, they'd been doing incursions up into South Sudan and had set up a few bases in South Sudan. And the Ugandan government launched an operation called Operation Iron Fist to try and get them out of the South Sudanese bases. And because of this relentless government offensive, the Lord's Resistance Army had to keep moving and had to keep moving. And so they needed porters. And because women are so practiced at carrying loads on their head, what they did is they went and abducted a whole bunch more women, because then they could use the women to carry the loads on their head. So I think that's just a really interesting illustration of the way that women participate in conflicts in Africa uses African women's participation in society as a model. Now, one of the roles that women fill in many African armed groups, far too many, is that of providers of sexual services. And it plays out differently in different groups. In some groups, you've seen one of the roles of women being just to be sexually available to anyone. So in many of the groups, for example, in Sierra Leone, such as the RUF, the women in the group could be raped by any man. And women who were part of the group described having man after man after man, often many in a day, come in and use them for sexual purposes. And that was seen as just what women in the group had to endure. Other times, women are allocated to specific men in what they call marriages, quote unquote. And there's different names for these marriages. They're called bush marriages or AK-47 marriages. And so often a woman will be given to a man and he'll be her armed grouped husband. And then she fulfills all the roles of a wife for him. She'll have kids with him. She's sexually available to him. She looks after his home. And in different groups, it plays out differently. One interesting example is the Lord's Resistance Army in northern Uganda, where depending on the seniority of the men in the group, the more senior a man was, the more women they would be allocated. And as of 2007, the last statistic I could find, Joseph Kony, who was the head of the group, was said to have 88 wives who had been allocated to him in this way. Now, these girls had to service their husbands, but they also kept their homes and they also fought. And, often when people talk about the women of the Lord's Resistance Army, they talk about the image of these women fighting with guns with their babies tied to their back. This is just one example of a woman that I met in northern Uganda. She had been abducted by the LRA when she was a teenager, and she had worked her way from being kind of a junior in the group. She was just a kid in the group, married to a man, and then stayed with the group for many years, eventually graduating to being the group doctor. So she learned how to treat people with herbs and with the different types of herbs that they found in the land. And her job by the end was to treat people. And I met her a few years after she had left the group in a demobilization program that was happening in the area. This picture at the bottom is just an example of some of the handiwork of the Lord's Resistance Army, where when they go into villages and towns and they want people to know that they were there and to get people to be suitably afraid and terrorized. One of their tactics is cutting off of ears and lips and body and facial bits. Some women join armed groups for much the same reasons as men do, because they strongly believe in the cause. You see women here who are as radicalized, who as strongly believe in what groups are fighting for as any men. But often, and in many contexts in Africa, you find women entering armed groups non-voluntarily because they're abducted and in a range of really, really violent circumstances. If you can have a read of just one, I'll read you this example. It's a girl aged 10 who was abducted by the RUF in Sierra Leone. She says, "They raided our compound and put everybody in the house at gunpoint. I was forced to carry ammunition and looted property on our heads to Kabbalah. It was so heavy, whenever we slowed our pace, we were beaten with gun butts. On reaching Kabbalah, one rebel deflowered me that very night. He was rough, he hurt me, and when I tried to fight, he slapped me on my face and tied my mouth so that I couldn't shout." And there's just testimony and testimony and testimony of kids who were kidnapped in this way, and thousands of kids were kidnapped by this group and kept for years. The example that you see here at the bottom, you will have recognized it from the news. These are the Chibok girls. But a really interesting example of abduction, which is kind of one of the big examples that's going on at the moment, is the group Boko Haram in northern Nigeria. And they've taken to kidnapping girls, and they kidnapped many. The 200 or so Chibok girls was an example that made it onto the news and became very well known. But sadly, that's just the tip of the iceberg. They're constantly abducting more and more girls. I was in northern in northern Nigeria for half a year working on this response, and it was absolutely heartbreaking. But it's a really interesting example of women's participation, because they kidnap these girls, they turn them into wives, they take them deep into the bush, into the Boko Haram bases, where the girls are isolated from anyone they know. They're forced to do really hard labor as wife. These girls sleep under trees. So, they sleep for the years they're like underneath a tree. That's the extent of their homes. But recently, one of the things that they've started doing is using girls for suicide bombers. So, Boko Haram can't get into the cities, and because the cities are quite fortified by the Nigerian military, and so they've got checkpoints around the city, and the men can't get in. So what they do is they strap suicide bombs onto these 12-year-old girls, and they send them walking towards the city checkpoints. And the instructions that these girls have is just walk as far as you can and see how deeply inside the city you can get. Your aim is to get into the center of the city and then to detonate. But if you get stopped at the checkpoint and they won't let you through and the soldiers are harassing you, just detonate there. Just, they tell them to detonate as far as they can. So they've been using hundreds and hundreds of girls in this way. And it's been really, really tragic because these girls are not very good suicide bombers. They're 12. They're absolutely terrified. They're not technologically savvy. And so most of the time you see these girls accidentally detonating themselves in a field far from the checkpoints. And what's even more sad is that you've got a phenomenon now of the Nigerian military's become savvy to the fact that suicide bombers come in the form of 12-year-old girls. And so what's happened now is that they see young girls approaching the checkpoints, and so they shoot them. And so there's been a marked increase in regular young girls getting shot because people think that they might be suicide bombers. They're underneath the burqas. So there's a real anxiety about what they carry underneath them. So yeah, that's just an interesting example of female participation in a group. These women are, for the IHL lawyers in the room, directly participating in hostilities because they're carrying a bomb which they're planning to detonate. But it's a really, really different understanding of direct participation in hostilities to what IHL scholars often talk about. I just want to say that, often I get very annoyed by people have this real binary vision of women being really peaceful and passive and men being really violent. And I'd like to dispel any of those notions. My work has shown me that women can be every bit as violent as men. Women across the African continent have perpetrated terrible acts, often against civilians, and really, really terrible acts, which some of them have been very committed to doing. In other contexts, women have been forced to commit acts of violence. So if you think about a country like Sierra Leone during their war, one of the ways that the groups such as the RUF used to bind the women to the group was that they'd force them to commit terrible acts of violence towards their own families and communities. They'd force them to go into their families and communities, to kill people, to maim people. And that was a way, then the girls would know that if they left the group, they would never be able to go back to their community because they'd wronged them so much. And that was the way that the group got people to stay with them. And then finally, before we move on to the law, I just want to talk about the numbers. I don't want to overstate it. My talk really very much focuses on women in combat, but I wanted to just acknowledge the fact that women in combat are still very much the minority. You know, combat is still very, war fighting is very much a male-dominated activity. The numbers of women in African militaries and militias are very, very hard to come across. Surprisingly, it's actually harder to come across the numbers of women in state armies. What I could find, the last statistic that I could find was a 2008 statistic, which is that the average of women in African armies was 5%, which is in line with the average around the world. So the average around the world is about 5%. The Southern African regional average is 10.5, so it's quite a lot higher in the southern part of the continent. And in my country, where I live, South Africa, we've got the most gender-integrated military with 27% women. Non-state armed groups, interestingly, have sometimes much higher amounts of women, but there's been a lot of variation. Some of them have no women, some of them have quite a lot of women. But some of the groups have had around 30 to 40% women, such as the Sierra Leonean groups, some of the groups in the DRC, some of the groups in Eritrea. So you've actually had groups where women have been like extremely dominant members. Okay, so moving on to the law. I'm going to just stop on the principle of distinction for a minute. I know that there's some people on the call who are not lawyers, although I know that most of the people on the call are IHL lawyers. So I'll just spend like an extra 30 seconds here to get the non-lawyers up to speed. So the principle of distinction is one of the core principles of international humanitarian law. International humanitarian law is the body of law that regulates the hostilities, that regulates what people can and can't do when they're fighting wars. And there's a few kind of primary core principles in international humanitarian law, the very most important principles. And one of these core principles is the principle of distinction. And effectively, the principle of distinction says that you have to distinguish between civilians and combatants. You have to distinguish between those who are fighting and those who are not fighting. And you are allowed to target those who are fighting, the combatants, and you're not allowed to target those who are not participating in war. And that's the absolute one of the essence of the laws of war. It's one of the main legal protections in conflict, is this rule saying that you have to separate combatants and civilians, and only combatants or fighters are legitimate targets of war. Now, a complex set of laws have set out the requirements and the definitions aimed at distinguishing who's a civilian and who's a combatant and who's a fighter. And they've told us who's a combatant and who's a civilian in order that we can know who can and cannot be a target of attack. So the law does two things. First of all, the law mandates that fighters respect the distinction between civilian and combatant. And second of all, the law delineates that distinction. It sets out who is which. It sets out the distinction. And what's important to remember is that that's been a fluid distinction. The law set out the parameters of who's a fighter and who's not a fighter. And these definitions have shifted over the years with the various different international humanitarian law treaties that have come over the years. This definition has grown and shifted. So it's not a rigid matter. Who's a civilian, who's a fighter, and who's a not fighter is not a rigid matter. It's a subjective thing which has been created by the drafters of the law over the years. Give me 1 second too. Okay, so let me quickly just run through the law, because this is what we'll then apply. The lawyers on the call on the webinar will all know that there's a difference in the way that this law applies in international conflicts, which are conflicts between states, and non-international armed conflicts, which are conflicts within a state. Now, the situation is much easier and much more clear in international armed conflict. Everything is much more clear legally in international armed conflict because there's much more law that regulates international armed conflict. We have the 4 Geneva Conventions that regulate international armed conflict and the first additional protocol, and they set out a lot of different details. So it's a much clearer regulated space. Now, let's talk about this one first. In international armed conflicts, we have a distinction made between civilians and combatants. Now, the law then sets out who is who. What do they say? Well, civilians are defined negatively, which means that civilians are everyone who do not fit into the definition of combatants. So that's the negative definition which is used. So then who's a combatant? Well, the Geneva Conventions tell us this by telling us who's a prisoner of war, because people who are prisoner of war people who are combatants are entitled to prisoner of war protection. So it gives us the requirements for who's a prisoner of war, and these have become our requirements for who's a combatant. And these requirements are that they need to belong or be acting for a state party to a conflict. So it's only people fighting on behalf of a state. They need to be subordinate to a responsible command. There's got to be a command structure. They have to have a fixed distinctive emblem. They've got to show themselves to be a member of the group visibly. There needs to be something that marks them as a member of the group. They need to carry their arms openly. They need to act in accordance with the laws of war, which is a very important criteria. And they need to have a level of organization and discipline. So those are the criteria to be prisoners of war, which are the criteria to be combatants under the law. Now, it's an interesting system because in terms of this law, being either a civilian or a combatant comes with privileges, restrictions, and obligations. It's a balancing system. So civilians there's privileges and obligations on both sides. Civilians do not have the right to participate in hostilities. They're not allowed to fight. And if they fight, they can be prosecuted. Civilians do not receive prisoner of war status. But the most important thing is that civilians have this legal protection from attack in terms of the principle of distinction. So they have this biggest protection of all. On the other hand, combatants don't have this protection from attack. Combatants can be attacked. They can lawfully be attacked. And combatants can be attacked at all times, even when they're not fighting. Even when they're sleeping, they can be attacked. And combatants remain a legitimate target of attack until they withdraw from hostilities. Until they're no longer involved in hostilities, they're targetable. But while they are able to be attacked, being a combatant comes with a number of privileges. And in law, in IHL, we talk about this being a privileged status, a combatancy being a privileged status. So what are the privileges that come with being a combatant? First of all, combatants have the right to participate in hostilities. They're allowed to fight. And importantly, then they can't be prosecuted for the normally illegal acts that make up war fighting. So if a combatant kills somebody in the course of fighting a war, they can't be prosecuted for that if it was in accordance with the laws of war. So they can't be prosecuted for fighting which is in accordance with the laws of war. And then another privilege is that on capture, combatants acquire prisoner of war status. So if they're captured, they're entitled to be treated in a certain way. Now, in exchange for these privileges, combatants have to keep certain obligations. And these obligations are, first of all, they're obligated to comply with the laws of war. So that's a big one. And then another obligation is the fact that they must physically mark themselves as combatants. They can't wear a disguise. They have to show themselves openly to be a combatant. And what you see is that these, the privileges that they receive are an incentive for keeping these obligations. So in exchange for them keeping the laws of war and in exchange for them visibly marking themselves as combatants, they receive all of those privileges. And that's how it's an incentivizing system. In exchange for keeping the rules, they get the privileges. Okay, so that's the international armed conflict. Now we get to the much more messy and much more difficult one, and in my opinion, the much more interesting one, which is non-international armed conflict. So unlike in the international armed conflict where you had 4 Geneva Conventions and the first additional protocol, in non-international armed conflict, you have much less law. You have, out of the 4 Geneva Conventions, you got one article, Article 3, Common Article 3, that applies to all 4 Geneva Conventions, which is applicable to non-international armed conflict. So that's, instead of all 4 conventions, you got one article out of all of them, which is about 15 lines. And then you've got additional Protocol 2 to the Geneva Convention. So it's much less law. It's much less law, and what you find is a situation which is often much less clear and much more controversial. Now, in non-international armed conflicts, you don't have the civilian combatant divide that you do in international armed conflicts. Anyone who's not fighting for a state doesn't have a right to be a combatant. And why is this? It's because states, who are the ones that negotiated and drafted the whole IHL system, they didn't want to give this privileged status, and they didn't want to give any sort of legal recognition to militias within their country who were fighting against them. They had these people fighting them within their country, fighting liberation struggles, fighting whatever they were fighting, and they didn't want to give them status, and they didn't want to give them privilege. So they set up a system whereby they created no combatant system for non-state fighters, for people in non-state armed groups in non-international armed conflict. But despite the fact that they didn't want to give them any of the status, states still wanted to be able to shoot them. They still wanted to be able to target them. So what did they do? They created this concept of direct participation. And Article 13.3 of Additional Protocols 2 states, civilians shall enjoy the protection afforded by this part unless and for such time as they take a direct part in hostilities. So civilians have full protection unless and for such time as they're playing a direct part in hostilities. When they're directly participating, playing a direct part in hostilities, they lose their protection from attack. So in non-international armed conflict, the key determiner, the most important thing, this determiner that determines whether people can be targeted or not, is this concept of direct participation in hostilities. But the problem is that the treaties provided us with almost no clarity about what this term actually means. The treaties don't properly define the term, and scholars have had a myriad of vastly conflicting, differing opinions about what this term means. There's as many opinions as there are scholars around what actually constitutes direct participation in hostilities. So you're left here with this like absolutely critical thing. It's the key determiner, the term that determines whether people can be targeted and killed or not, but it's a term which is incredibly unclear, very, very complicated, and on which there's almost no consensus about. Now, moving away from stepping back from the details of the law, let's just look at why it's important. Why is this principle absolutely critical? It's critical because confusion, either in fact or in law, about who's a civilian and who's a combatant, or who's a fighter and who's a not fighter, will ultimately always land up with more civilians being killed. Where fighters can't tell the difference between whether a person's a fighter or not, you're going to land up with civilians being killed. And if the law doesn't make it crystal clear who can be targeted and who doesn't, it's always going to be civilians that bear the brunt. And that's why it's absolutely critical that this distinction be demarcated clearly. But the problem is that what we've seen in recent years is that this is much easier, like the principle of distinction is clearer on paper than it is in practice. And in recent years, you've started to see in conflict after conflict a lot of situations which make it increasingly difficult to work out who's who and how the principle works. I want to tell you a very interesting statistic. Around the turn of the 20th century, civilians, so about 120 years ago, civilians made up 5% of all deaths in conflict. Civilians made up 5% of deaths. Around World War I, civilians made up 15% of all conflict deaths. Around World War II, that went up to 65% of all deaths in conflict were civilian deaths. In the conflicts of the last 20 years, 90% of all deaths have been civilian deaths. So what we really see here, what we see here clearly is that the principle of distinction isn't working. This thing in our law, which is designed to protect civilians from being shot, it's breaking down. It isn't working. We can see over and over that it's not working. Now, what's so difficult about it? Now, in the olden days, 100 years ago, the olden days, in some ways it was much clearer. You saw wars being fought on trenches, on battlegrounds. The battlegrounds were separated from the city. Men were wearing uniforms. They were fighting each other away from the city on battlegrounds. So it was much clearer who were the fighters. But today, think about the modern conflicts that we see. Today, so many of the conflicts that are being fought in the middle of urban centers, where people are conducting strikes and then like disappearing into the urban background. Today, so many of the fighters that we see are not wearing uniforms and not marking themselves. You also see today more and more civilians taking part in hostilities in different ways, with civilians supporting groups quite actively in the fighting of war. And then you see a number of these really challenging groups today, which have really, really made it difficult to apply the principle of distinction. Think about terrorists and the difficulties that terror groups have created for working out who's a fighter and who's a non-fighter. Think about child soldiers. That's another one of them. Think about private civilian contractors, which are also very dominant on today's modern battlefields. So you've got all these groups which are increasingly dominant and prevalent in modern conflict, but which really like turn the principle of distinction on its head. And the result is a principle that's a principle that's in crisis, a principle where a situation where 90% of deaths in conflict today are civilians shows us that this is a principle that's no more working out like it's supposed to be. Now, let me look to the gender issues. Now, formally, the principle of distinction, as much of IHL, IHL is a gender-neutral body of law, and the principle of distinction is a gender-neutral principle. It applies to men and women in the same way. There's nothing in the law that says that men have to be fighters and women have to be civilians. In fact, the law is very clear about the fact that it both can be both. And there's a number of provisions in the law that specifically demonstrate to us that the law was envisaging that there could be female fighters. So, for example, there's provisions around the way that female POWs should be accommodated, and the fact that female prisoners of war should be held under the supervision of women. There's rules saying that there should be separate bathrooms and sanitary conveniences for female prisoners of war. There's, in non-international armed conflict, there's a provision for the fact that women deprived of their liberty must be held separately. The law, there's many places in the law where the law makes it clear that they were envisaging that women could also be fighters. But I think that's as far as it goes. I think if you look at the law, if you dig a little deeper, you start to see that the law is not actually quite as gender neutral as we thought. And if you look at the history of the law, what you see is that the predominantly male drafters of the IHL system had very particular views of men and women in mind. And those views have very much percolated throughout the development of this law and remain evident in the law today. And that these views were that men were the combatants and women were the civilians. And I'll just give you a few examples that show us how this has percolated throughout the history of this body of law. We go back to Hugo Grotius, one of the founders of legal thinking. In the 17th century, he's one of the founding thinkers of the laws of war. In the 17th century, Grotius noted, I quote, "Children should always be spared, women, unless they have been guilty of an extremely serious offense, and old men." And in his reasoning, Grotius reasoned that women should be spared because they do not have the capacity to properly devise war. And his logic was that much in the same way that children do not deserve to be killed because they have not yet attained the use of reason, so too women should be spared because they haven't yet attained the proper capacity to devise war. Now, he's not the only one who had these views. Many of the Enlightenment theorists also had similar ideas about the immunity of women based on women's innocence, on women's inherent inability to wage war. So Francisco Suarez was another one of the famous Enlightenment thinkers. He said, I quote, "It is implicit in the natural law that the innocent include children, women, and all unable to bear arms." So throughout the original thinkers of the laws of war, you've got these ideas that women are innocent, they don't have the capacity to do the war. And in contrast, you've got the opposite attitude being given to men. Men, well, in the same way that women were viewed as innocents, men were viewed as guilty and were viewed as perpetrators and as presumptive combatants. For an example, Victoria, the Enlightenment theorist, noted, "Everyone able to bear arms should be considered dangerous and must be assumed to be defending the enemy king, that they may therefore be killed unless the opposite is clearly true." And so this idea about men being all presumptive combatants, or the men being the bad guys, has been actually really, really bad for men. And in war after war, what we've often seen is large-scale sex-selective killings of men because of this notion that men are the presumptive combatants. You know, in the last years, you saw it in Srebrenica in Bosnia. You saw it in ISIS's attack of Yazidi men in Sinjar in Kurdistan. So, you know, you've seen a feature of many conflicts has been large-scale killing of men because of this notion of men being presumptive combatants. Those were the founding thinkers of the laws of war. I would like to argue, though, that in recent years, with the Geneva Conventions and their additional protocols, these ideas have continued, although they have been couched in slightly more subtle terms. But you still see these ideas percolating about women and men's respective places in the minds of the drafters. So, for example, in the Geneva Convention, you still have these ideas about strong men and weak women, and they're evident in numerous places. I'll give you an example. Article 14 of Geneva Convention 3 says that women shall be treated with all regard due to their sex. And then the Geneva Convention's commentary and analyzes what did they mean by this comment, women should be treated with all the regard due to their sex. And they talked about it, and one of the things that they came up with considerations like pregnancy, but they also came up with considerations like weakness. So women should be treated with due regard to their sex because of women's weakness. So these were the ideas underlying the drafting of the Geneva Conventions about women's weakness. Another thing just to point out that is out of the IHL often paints women in either two ways, as victims either as victims or in terms of their relationship to others. So out of the 42 provisions in the Geneva Conventions that specifically deal with women, more than half of them deal with women as childbearers or mothers, and all the rest of them deal with them as victims, and most of the rest of them deal with them as victims in some way. Okay, so let me tell you a little bit about what happens when you apply this law to women. So, you know, clearly the law envisaged that there'd be female combatants, but I was wondering what happens if you actually take this law, the law as we've got it, this slightly gendered law which is written with this particular view of men and women in mind. What happens if you take this law, and what happens if you apply this law to the women who are actually actively participating in conflicts today? And for me, in my work, I was looking at women in African conflicts. So if you take the women who I described in the beginning of the talk, participating in all those ways in African conflicts, and you apply the law to them, what does it look like? How are these women classified? Are these women combatants or civilians? Are they direct participants? And what are the effects of this? Are the results good or bad for women? And so I did this. This is an exercise that I did over a few years while I was doing my doctoral research. And I wanted to just present to you some of the results. And I'm not going to talk about specifically, I'm not going to talk about the specific application of the law. If you're interested to see, like, you know, I applied it to many, many groups of women training, and women carrying weapons, and women in this group and women in this group. And I did the full evaluation, like working out how the law applied to them. If you're interested, this is in my last book. Happy to share a copy, and you can see the legal analysis, but I'm not going to go into that now. Rather, what I want to do is step back and just tell you a few observations that I did from these legal applications of the law to women in African conflict. So, a number of observations. The first observation that came out of trying to apply this law to those women in African wars is that it was incredibly, incredibly difficult to apply the law to these women. And why was it so difficult? It was simply because the categories in the law looked absolutely nothing like the woman that I saw in practice. It was like apples and oranges. It was like applying categorizations that seemed to have nothing to do with the realities that I was seeing on the ground. And I think that this is not only a problem that applies to women. I think you could probably make the same argument that if you applied the laws of war to child soldiers, the same thing would happen. The law argument has been made that if you apply the law to terrorists, the same argument can be made. But my first observation was that applying the law to these women is difficult because the categories in the law just didn't match the reality that I was seeing. But taking it further, the main finding that I made was that when you applied the law to these women, very, very, very few women qualified as combatants or as those directly participating in hostilities. The definition, the DPH, direct participation in hostilities, and combatancy and are very, very narrowly defined concepts. They keep them very narrow. And when you take the definitions and you apply, if you think about the definition of direct participation in hostilities, when you take that and you actually take the different types of things that women are doing for various armed groups in Africa, and you apply the definition to them, most of the things that women ever do won't meet that definition. And just to say, for the IHL people on the call, I used the ICRC's interpretive guidance on direct participation in hostilities using their kind of like revamped understanding of how these can be applied in modern conflict, and their definitions of continuous combat function. And I really got into the nitty-gritty of like applying the specifics of that law to the different tasks that women were doing, and almost all of the time, most of the time, women didn't qualify as direct participants. So what is the effect of this for women? Is this good or is this bad? And the answer is that it's mixed. You know, if women are not fitting into the definition of direct participation in hostilities and into the definition of combatancy, what this effectively means is a woman have protection from attack. It means they can't be killed and can't be targeted. So from a purely like legal protection point of view, this is a very good thing for women, and this is certainly not anything which somebody would want to take away. But I was much more interested in exploring what are some of the potential, like, less seen negative implications of this. It's clear that giving women having more protection from being attacked is a nice thing, but I had this intuitive feeling that there was more to the story, and I wanted to explore, like, what are the consequences of the fact that the law pretty much shuts women out of these very narrowly, quite male-focused definitions. So the one thing is that these restrictive definitions that exclude women from their definition, they propagate the view that women are not actively participating in conflict. So, and these perceptions are already around in society. You already get these stereotypes in society that women are not actually properly participating, they're not actually proper soldiers. But what the laws of war does by excluding women from the definition is it entrenches these. It sort of gives it a legal stamp of approval. And in this way, the law is kind of playing its additional part in concealing the roles that women are doing. Women are playing many active roles, but by the law not being broad enough to encompass those roles, the law is playing a part in concealing those roles. The other thing that I think is that in doing this, the law, it encourages non-compliance. Like, the one thing which is very, very clear to me is that the roles that women play in combat in Africa, in armed groups in Africa, are roles that armed groups are highly reliant on. Groups can't keep going without these roles. They're reliant on these labor, whether it be the domestic labor, whether it be the support labor, all of these types of labor. The groups very much need these women. That's why they abduct so many women. That's why they recruit so many women. And so if fighters on the ground, if the enemies on the ground are aware of the fact that the women are doing so much, and they're aware of how dependent the groups are of these women's contributions, enemies on the ground are not going to be prepared to not target them just because the technicalities in the law don't allow for it. You know, particularly in particularly weaker parties who may not feel they have the luxury of ignoring the opportunity to strike those who are integral to the maintenance of their enemy's forces. And so I think that restrictive definitions that don't allow people to target those who are taking part actually create, they actually support non-compliance with the law. By not allowing fighters to target those who they know are acting against them, this creates a disincentive to abiding by the law. So that's another reason why I think that these narrow definitions which exclude women are problematic. A few more things. First of all, I think that conceptualizations that paint all women as the victims of war tacitly allow for or normalize the further victimization of women. And that's a problem. And then in addition to that, I think that this perception that women are not real fighters, are not real combatants, also contributes to women being discriminated and harmed by their male peers within their own groups. So those are some of the things during conflict. But I think that the effects go after conflict as well. I just wanted to stop and show you this photo. I took this photo of a woman in Central African Republic. She had been a fighter and had left the group and had a really, really hard time post-conflict, as so many female fighters often do. And I sat with her the one day while she nostalgically showed me her picture of the good old days, her glory days when she was involved in the militia, as opposed to the current days where she was suffering so much. The principle of distinction also has negative effects which carry on in this incredibly difficult moment for women once they leave militias. You know, if you've got this law which paints women as not being real combatants, it doesn't recognize women's roles as real participation or real combatancy, what you see is that women are then excluded from the spoils. And by the spoils, I mean they're excluded from participation in peace negotiations. They're just excluded from reparations programs that happen post-conflict. They're excluded from demobilization, DDR, disarmament, demobilization, reintegration programs, and as well as from post-conflict political positions. So this, you know, if the body of law which creates this feeling that what women is doing is not being proper participants, this discriminates them after the war when their participation is then not properly recognized and they're not able to enjoy in the way that other participants in war were able to enjoy post-conflict. Another thing to think about is that women often have an incredibly hard time after conflict. So after following armed conflict, security issues often remain after a while. So you have a peace negotiation signed and a war officially ends, but the fighting may linger. And what you often see is that people go back to their communities. People who were previously fighting each other go back to the same communities. There's a lot of hostility. There's a lot of hatred. And you still often see a lot of violence. And you often see a lot of violence against women in this period. And that's both outside the home and inside the home. You know, there's a lot of evidence that shows that rates of domestic violence against women and sexual violence against women spike in the post-conflict period. So what you've got is this moment in time where the laws of war cease in their application. Peace is made, the laws of war cease to operate, yet the threats that women face from war have not stopped operating. And right then, as the risks have while the risks are still there, this protective body of law ceases to operate. And in some ways, that's another failing of this body of law for women post-conflict, is that the law stops its operation before the moment when the risks caused by the war are actually gone. A few other problems. First of all, the principle of distinction is outward looking. It protects women from acts. It protects people from acts of the enemy. It says who can and can't be targeted in the enemy, but it doesn't protect people from those within their own within one's own side. It's only from the enemy. And what it misses is the fact that in conflict, so much of the danger that women face is from those within their own side. You know, we've got so much testimony about the experiences that women have within armed groups of being raped, of being attacked, of being brutalized. Women are often really badly harmed by people within their own ethnic groups, by people within their own sides to a conflict. But the principle of distinction doesn't look at that. It's only focused on the enemy. And some might say that in that way, the principle of distinction is partially blind. It's got a blind spot. It's not seeing a lot of the ways in which women are at risk. Women are not only at risk from the enemy at war, they're also at risk from this side. And you know, the counter argument could be that IHL wasn't designed to regulate that sort of risk. IHL was designed to regulate a risk from an enemy, and that IHL's effectiveness is from its narrowness. But I still think that if the law fails to acknowledge the different sources of danger that women face, then it is failing to provide a comprehensive protection for women in war. This is one I find really interesting, and I know it's very controversial. And I mean, I think this is such an interesting, I guess, piece of research that still needs to happen. But I think that a real limitation in the principle of distinction is the fact that it doesn't take into account considerations of voluntariness. You know, voluntariness is not an issue, you know, in whether somebody can be targeted or not targeted. If somebody's a combatant or a direct participant in hostilities, they can be targeted regardless of whether they want to be there or not. And, you know, we've known that there's been like compulsory state conscription for years, and we've never seen that as being a problem. Voluntariness is just not a criteria in this particular area of law. But that feels intuitively unfair when you look at women. If you think about the circumstances in which women were kidnapped and taken into these groups, and so many women are recruited forcefully and forced to do these things in groups, it feels to me that that is a body of law around protection which doesn't take that into account. There's something serious missing there. You know, if you think about the women who are abducted into African groups, it seems the lines between female fighters and armed groups' wives and sex slaves are so blurred. Think about like women in Boko Haram, which is in the bottom picture here. You know, they're young girls who are abducted. They're forced to be wives. They're often forced to be suicide bombers. They're forced to play support roles for the group. They're the whole combination of sex slave plus fighter plus everything all in one. You know, across the literature of armed conflict, you see terms like female combatants, women associated with armed groups, sex slaves, forced wives, rape victims. But what I've actually come to understand is that these terms are so blurred. You know, you can't separate a female combatant from the rest. They're absolutely interblur. And I think that the principle of distinction's failure to take into considerations any of these issues of voluntariness is, I think a problem. You know, the principle of distinction provides protection to people because of some notion of the fact that they're not deserving of attack. But it seems to me that women in these circumstances, who are recruited in these circumstances and who are participating in these circumstances, are equally non-deserving of being attacked. And so that feels to me like a real flaw in the system, right? You know, think about a girl. You think about the story I told you of Boko Haram, a 12-year-old girl who's had a bomb strapped upon herself and is sent to walk towards a checkpoint to detonate herself. You know, that absolutely is direct participation in hostilities in a very awful sort of way. And the laws of distinction have not given us a way to get around this. You know, in the ICRC's interpretive guidance, they've sort of slightly opened the door to this issue in the discussions around human shields, maybe not being able to be targeted, but it's absolutely just a crack in the door open. And at this point, this is still an area of the principle of distinction, which I think much work needs to go in, and I think a change is needed. How are we doing on time? Are we still okay? Or should I wrap up? Okay, last 2 minutes. So
you have a few more minutes, Orly.
Sorry?
A few more minutes, Orly.
Okay, cool. So just another problem is that often the idea about in the law about who's a combatant and who's a civilian, or who's a participant and who's not in the law, differs so much from what people see on the ground. And I think that that's a problem. I'll give you two interesting examples. The SPLM, which is the liberation movement in South Sudan, they used to they recruited hundreds and thousands of women during the 30-year civil war. Many thousands of women were recruited. But quite early on in the war, a decision was made to not let women go into combat. You know, they had, early on in the war, they created a female combat battalion called Katina Banat, which was a disaster. They had one combat operation, which was an absolute disaster. Lots of people got hurt. And soon after, it was decided that women were no longer allowed to serve in combat. But the SPLM still recruited thousands of women, and women rose to leadership positions, and women considered themselves to be combatants, and women were considered to be combatants by their peers. And importantly, women were considered to be combatants by their enemies and were targeted as such, even though none of those women would have met the definitions of combatancy or direct participation in the law, right? And then the opposite example is you've got a situation like the Lord's Resistance Army, which has kidnapped thousands and thousands of children, and including women. And these have been, they've gone into battle, they've fought, they've laid bombs, they've been actively involved in combat, but they've been understood by the Ugandan military as being kidnappees, abductees, and victims, rather than as being combatants. So you've got the situation where they actually are shooting and participating in hostilities, but the army that's fighting them are treating them with kid gloves and treating them as victims rather than treating them as combatants. So it's really interesting, that distinction between the way that these are perceived on the ground. But for me, what's most disturbing is that these different ways in which these are seen on the ground are completely different to the ways in which they're seen by the law. And it seems to me that if you've got a law which is creating an understanding of combatancy, which is so different to the ways that you're seeing it on the ground, how can you ever hope to have people keeping the law? Like those differences really are, in my opinion, a source of non-compliance. So let me wrap up by just a couple of summing up arguments. Does the principle of distinction serve women in conflict? And is it beneficial to women, or is it not? And I think my answer is it's mixed, it's both. On the one hand, you've definitely got women benefiting from the fact that they don't meet the definitions of combatancy and direct participation so often, because it gives them legal protection from attack. It means that women are legally protected. But on the other hand, I think that because of the various small and negative things that I've been pointing out, those are also bad. So I think that the answer is mixed. Now, it might be that the legal protection from attack is much more important. You know, it could be that that one feels that those are much more important and outweigh the small and negative things that I've pointed out. But my opinion is that, you know, my opinion, I've gotten into a lot of trouble for this in many talks that I've given, is that, like, equality is a really important thing. And if we want to be truly equal, we need to be, you know, if women are fighting in wars, they should be targeted as men are. And, you know, equality means equality for people when it's good and where it's bad. But in this talk, I'm not propagating for changing the law in many ways. I'm just saying that what I'm trying to do here is just paint the picture of it and show that there is some good and there is some bad. There is this additional protection for women that they get because of the fact that the definitions are narrow. But there's also these many longer term indirect effects, which I think are really important to note. Because if the law is playing a part in kind of creating these societal protection understandings of women, I think that that's an important thing to take note of. Why is this important beyond gender? And this is the slide that I'm going to close off on. I think that we know that the principle of distinction is failing. 90% of civilian deaths, 90% of deaths in conflict being civilian. We know it's a principle that's not working. And I think that this assessment of women gives us an illustration. It gives us some clues as to why, because I think what's happening for women is happening for other groups too. I think that one of the things that if you apply the law to women in African armed groups, what it starts to do, it shows us that the laws are based on categories that are not reflective of the real conditions of conflict and of actual ways in which people participate. And I think that regulation that's premised on inaccurate or unrealistic categories can never optimally regulate. And so I think that it's an important thing because of that. I think that women also show us if the law is not working properly when you're applying it to a quote unquote challenging group like women, even though women are 50% of all people in war, it shows us equally how badly the law works for other difficult groups, other groups that veered from the ideas that the drafters had in their minds. And so, yeah, these are just some of the reasons why I think that this application gives us some important clues into why the law as a system is not working so well. Let me end there and open it up to questions and discussions. If anybody is interested in reading it in more detail, this is the book where this is all set out in. These are my contact details. Please feel free if you want to chat about it, debate a point that you didn't agree with, or just get in touch generally. And yeah, let me open it up to discussion. Thanks.
Okay, so Orly, first of all, thanks a lot for an amazing presentation. We'll open the floor for Q&As. We don't have a lot of time, so I think what we'll do is we'll pick up 2-3 questions for first batch, and then if we have enough time, we'll pick another one. I'm following both the chat, and those of you that want to ask questions can either post them on chat or raise your hands. We have a first question from Eitan, so I'll give the floor to Eitan. So Eitan, you have the floor.
Thanks, Tom, and thanks, Orly. That was really interesting. So I wanted to ask, well, I had a few questions, but I'll ask one about this notion of the voluntary nature of participation, or rather the fact that women are compelled in many cases to fill or not that should figure in targeting. So it seems to me pretty clear why that could be a consideration once a woman who was compelled to fight is, for example, captured. So if you're assessing whether her actions constituted a crime of a war crime or a crime because of the fact of participation without being a combatant. So that's easy to understand. But I think with targeting, it's much trickier, because from the perspective of the party that's being attacked, whether a child is attacking them because that child has been compelled to do so, or a woman is attacking them or a conscript is attacking them because they're being compelled to do so, or whether this is someone who's doing it because they're a zealot and they really want to attack you, they still pose a threat. All these people pose a threat, and the targeting rules allow you to respond to that threat and neutralize it. It seems really difficult to say, no, well, this child or this woman was compelled to do it, so you have to just sort of not shoot back and accept the risk. Yeah.
I mean, it's an incredibly difficult question. Like I realize that what I've said is completely not enough. I've said that I think that this is inadequate and we need to do something else, but I haven't said what I think should be done. And you correctly point out that it's incredibly difficult to work out how it could be, because people do need to protect themselves. If you see a little 12-year-old walking with a burqa on and fearing she may have a bomb on her and she's going to kill you, I understand that people want to be able to react. But so it's tough. There's not been a lot of writing about this. I mean, this is an area of IHL which is absolutely, I think it's a PhD topic or a book waiting to happen for somebody. There's been one really interesting piece where a guy came up with an idea of, I can't remember his name, super something combatants for children. And his idea was that he wanted to say that if you saw a child combatant, you would make a different set of presumptions. Instead of, that for people who were clearly children, you would start saying, you would look at them differently. You would not shoot them in the same way, because you would make a presumption that a child is innocent and a child's not doing this in the same way as an adult would. And so an argument was, you could, it's problematic because it doesn't let people react when they need to, but it does start to, I think that there's something very important about figuring out a way in which these kids or women who've been compelled can be treated differently. I have no idea what the right way to do it is, but I do think that it's an important thing that we need to start thinking about. Yeah, that's a very bad answer to that question. I don't know what the answer is. It's an incredibly difficult and I think a really important question.
Okay, thanks, Orly. I think it's interesting. It's an interesting question, but also very difficult given the other difficulties that we face with the principle of distinction in conflicts in general, in current conflicts in general. I have another question from Itamar, so just a second. There you go. Itamar, you have the floor.
Thank you very much. I also enjoyed the talk and I thought it was really stimulating. I guess my my question is, to what extent the problems that you're pointing out to pertain to a particular part of the world and a particular set of both realities and imaginations of conflict in this part of the world, rather than being about gender more generally.
Yeah.
I think that one could also formulate a critique of IHL that starts from the question whether IHL is suited for, as you began your talk, non-international armed conflict more generally, and non-international armed conflict in particular cultural contexts.
Yeah.
So there's a kind of intersectionality that you're working with, and I wanted you to say more about the relationship between these two categories, where one, the gender aspect seems very explicit, and the other, the kind of cultural imagination aspect, seems much more in the background and not as interrogated in this specific talk.
It's such a nice question. You know, I think what I tried to do in my work was to put the margins at the center. So I tried to take a few of the atypical. If you think about IHL is envisaging kind of European men on battlefields. That's the way it was written originally. And I tried to take the atypical examples: Africa, the atypical continent; women, the atypical fighters. So I tried to take a whole bunch of the atypical and to make that the focus. And one of the reasons that I did that is because the atypical has become the typical today. You know, while most of the discussion in IHL still very much centers on certain types of wars, I would say that the bulk of wars today are actually wars that are fought on the African continent. So yeah, I mean, I think you're absolutely right. My findings were very much both African and female, but it was around, I think my focus was around atypical examples, and which are actually today the norm, but those which went so greatly against the visions of the drafters. Did that answer your question, or Itamar?
Yeah. I mean, it answers my question in as much as I understand that both categories are operative in your analysis. I guess the more specific point is whether basically the same analysis applies regardless of gender when you're asking about conflicts in Africa or in the Middle East, or maybe also in many other parts of the world. As you say, these are the typical conflicts today.
Yeah, I think it very much does. I mean, I think many of the problems that I've pointed out are not problems, just to do with women. They're problems to do with the type of warfare that we see in Africa. You're absolutely correct about that. You know, if you think about the ICRC's interpretive guidance on direct participation in hostilities, it sees a very particular type of direct participation, and it's a very, I mean, in my opinion, it's a very kind of tailored to the terrorist wars, tailored to terrorists operating in the type of insurgencies that you see maybe in the Middle East, in Afghanistan, Iraq, even in Israeli-Palestinian territories. It's a particular type of war. And I think that if you take it to the type of wars that you see in a place like Africa, you know, often much less mechanized, much less use of technology. In African wars, some people are still killing each other with machetes. You know, you've got much less surveillance. You know, the ways in which we're told to understand direct participation these days very much rely on being able to do surveillance on people to try and understand what they're doing at a particular time. Whereas in the African armed groups, you've got people serving from the bush, where, you know, you've got a group in the bush, and it's hard to know who's doing what in the group, you know, who's got a continuous combat function, who's playing what roles. You know, when people are out on an operation, it's impossible to know who's doing what. And so many of the ways in which we're told to work out who's a direct participation absolutely break down when you're looking at the kind of, you know, in some ways quite old-fashioned war fighting styles that we still have in the African continent, which are not these high intelligence, high technology, high mechanized wars that you see in other places. So absolutely, you're completely right. My assessment was partially about gender, but it was very much also about African wars. And I think you could say the same in many other different pockets. My criticism of the dominant school is that it's very focused on a particular types of wars and it's painting those as being the norm, when I think that those actually aren't the norm anymore. I think that, and that's as a kind of like African IHL scholar, that's my problem. It's like, I think we're missing what's actually the norm. And I actually, like, as with women, I think atypical fighters are also the norm today. You know, going back to Etan's question, I think, like, sadly, involuntary fighters are the norm. I think we've got all these new normals which just created this completely different landscape, which is so different to the landscape which IHL envisaged.
The floor is open for other questions. If anyone doesn't feel comfortable, feel free to write it in the chat, obviously. Okay, so I'll use my privileges as host and ask you, Orly, a question as well. Throughout the talk, you've reviewed the different roles that women play, and you've specifically focused on. You gave a focused example on Boko Haram, and you also threw it over to ISIS, the ISIS wives that we've encountered. And I was wondering if you think that. Well, I think, and I was wondering what you would think about it, that IHL doesn't, and also direct participation, doesn't treat quite properly those situations that are mixed. So as we say, the cook in the military, so in regular military, the cook would be a target, a lawful target. He or she wears uniforms, but in the context of armed groups, that's not the same. And I wonder if you would have if you thought of a solution, or have you seen, or have you been exposed to a solution how to solve that women that are actually serving not in fighting but in support functions, but are still being viewed as active participants in ways or another?
It's such a, I mean, I have not seen a solution. We're all looking for a solution. I will tell you a little bit about, you know, it's funny, I'm actually working very much on this issue. I'm working at the moment in Somalia on a rehabilitation program for Al-Shabaab defectors. So when men want to voluntarily defect from Al-Shabaab and wish to be rehabilitated, they can get amnesty and be rehabilitation. And I've been working on some research around trying to set up programming for female Al-Shabaab women. And one of the things we're really grappling with is this mixture between female members and wives. And we always get stuck with this. So if we're wanting to build a rehabilitation facility for women, who are the women that get to go in there? Is it the female members, or is it the wives also? And if it is just the female members, how do you tell the difference? Because half of the female members are married to men, and some, you know, there's this continuum of participation. You get wives who don't serve a group at all, then you get wives who just do things for their husband, and then you get wives who do some ad hoc roles for a group, and then you get wives who much more involved in the group, and then you get wives who are all the way to being members. But there's not two categories. There's this like absolutely blurry continuum. And so that's, I mean, we're looking at that question, you know, at the moment we've been drafting screening tools to try and, that security actors can use to try and work out which women are which and which women pose a threat. And are absolutely struggling. Like it's the hardest question to disentangle them. So, you know, you talk about the cook in the military, but I think that in a context like Africa, you know, it's often the wives who play these really who play the role of the cook and the sex slave and the fighter and the, you know, all of it all in one. To different degrees at different times, and nobody knows how to deal with this. Absolutely nobody knows how to deal with this. IHL certainly doesn't. But like IHL hasn't even started having this discussion yet. Do you know what I mean? Like these are not conversations that people are having in IHL about what about the women in Africa on the ground. And that's why I think that it's such an important space to be thinking about.
Thanks, Orly. I would love to hear what your thought after you finish the research in Somalia. I think it would be impressive to read that. I think we have two last remarks. I would give Itamar once a follow-up. So Itamar, feel free to jump in, and then I'll give you Dor for a short question.
I guess it's just a very quick follow-up to the previous conversation. As you were speaking, I was thinking about the film Eye in the Sky, which of course takes place in Somalia, and has this DPH and technological targeting aspect. And you seem to propose a kind of discontinuity between Middle Eastern terrorist wars and the African war, which I found very interesting and illuminating. I think in that film, really the kind of underlying suggestion is the opposite, namely the African war is a terrorist war, and it's perhaps even the paradigmatic most terrorist of all wars, if you think that the choice of that particular conflict is not just a matter of coincidence.
Yeah. No, I think you're right. I think when I said the terrorist wars, I think I was referring to the kind of American involved insurgencies in Iraq and Afghanistan as being the kind of wars that's like taken everyone's attention. I do think that there's been a shift in recent years. I certainly think that Boko Haram and Al-Shabaab would very much count as the terrorist wars. You know, I think we've got this really interesting new moment of war. I think you had the new wars, and now there's this new war, this new category of wars of like jihadist group insurgencies, which is the new dominant norm at the moment. So what started off in the Middle East has kind of trickled to Africa, you know, 5 years later. And it's, you know, it's almost like the next chapter that happened since my research. It feels like there's already been this new evolving, you know, I think that ISIS and Al-Shabaab and Boko Haram are like this new band or wave. But yeah, I absolutely agree with you. It's not the terrorist wars are. I was talking about that. You know, when I've talked about the mechanized and the intelligence, it's relating to kind of Western involvement. What I'm talking about in my research is more like Africa wars. It's like the ones without the external involvement. It's the one fought by African actors internally.
So Ido, quickly, I give you the floor as well, and then I think we'll wrap up.
Thank you. It was a very, very interesting presentation. Thank you for that. I agree pretty much completely with your bottom line. I think there are two premises at the beginning that I would like to a little bit challenge you with, partially for the sake of the discussion, but also because I'm really interested to hear your thoughts about it more than that. One is that your conclusion that IHL envisioned women taking part in the hostilities because POW's conditions are fitted to women. On that, but if we look at the definition of a POW, it doesn't. It's not only for combatants. There are only journalists and families who encompass and people who escort the armed forces are also entitled to POW status. And there are more chances that they will be women, well, not the journalists at the time, but definitely the people escorting the forces. There are more chances that they will be women than the combatants. So on that one. Another one is on, I've been reading quite a lot recently about the development of IHL in the 1800s. And there were some criticism back in the time about the principle of distinction that has been quieted down, at least later on, as far as I know, that the whole purpose of the principle of distinction was not to spare civilians as much as to give more power to the organized, strong military forces at the time, so they will have a built-in advantage within an armed conflict, where the other ones, there are weaker ones. That basically asymmetric warfare discussion of today was already some of the basis of that. That criticism has been quieted down for quite a long time, as far as I know. Maybe you know otherwise, or something else. But I think it challenges the notion of the development of armed conflict, that today civilians are dying more. Where, yeah, it probably has been that throughout the times, but IHL was built to give some advantage and not necessarily to spare civilians.
Yeah, I think that's right. I mean, I think that's exactly right. Yeah, I didn't. Is there a question to answer, or I
thought about it.
I think that's right. I mean, I think that the whole thing has been your point is that that the system was made to give power to the I'm sorry, I didn't actually understand. Can you repeat Will you
the second
repeat?
point.
Yeah.
Yeah, that IHL, that the principle of distinction was not meant to spur civilians, but rather to give more power in the battlefield to the organized military forces over the stronger military forces that have better equipment and have more soldiers. Therefore have combatants. Therefore, you have that distinction over the weaker states and armed forces at the time.
Who would be forced to use more civilians in their fightings?
Who would be prevented to use civilians, therefore, because of the principle of distinction.
That's really interesting. Yeah, no, that's very interesting. Yeah, I would like to read that. I don't really have a comment. I would love to read and hear more about that. If you would be willing to send me that.
Yes.
Yeah.
Sure.
Okay, so given that it's 6 minutes to 10, I'll wrap up quickly. I have to admit that I was excited, fascinated, and super supportive of Orly giving a speech in this forum. It kinds of combined everything that I'm passionate about, so armed groups, gender, and IHL. And it fulfilled my expectations, Orly. It seems that not only while your research focused mainly on inter-Africa conflicts, me at least, I'm able to draw those similarities or points of thought to other conflicts that I myself reviewed and worked and researched on. And I believe that any participant would, and I would be excited to follow up and read other research that you've had. It was an amazing talk and amazing questions from the crowd and comments. And well, we hope to see you live as well one of these days. So stay safe, all of you. Thanks for joining us. Thanks for Minerva Center in Haifa. Thank you, ALMA, for participating. Thank you, Dvorah, for indulging this idea. And thank you all for taking the time to be with us. Have a great evening, morning, or noon, wherever you are. Bye.
And from me, thank you so much, everyone, for your amazing questions and listening. It's been really nice to talk to everyone. Thank you.
Thank you very much.